manslaughter. Thank you.
Thank you, Counsel. Santiago-Rodriguez versus State. You can begin when you're ready.
Thank you, Your Honor. Good morning, Jessica Bonaro on behalf of Ms. Santiago-Rodriguez.
Are you Mr. Bonero's daughter?
Daughter-in-law, yes ma'am.
Daughter-in-law?
Yes ma'am.
Never met you before. Known Mr. Bonero for years. It's good to have you here. Is this your first
Thank
argument?
you. No ma'am, it's not. It's my second.
All right.
Thank you.
Go ahead.
Your Honors, the reason that we're here today is it's an entrapment defense question. Looking at the entrapment defense with the evidence that was presented at the motion to dismiss hearing back in January of 2010 and using the three-part test that the Supreme Court laid out for us, I'm here to argue to you that it does meet the entrapment and that the judge should have granted the motion to dismiss and not denied the motion to dismiss to submit it to a jury. There are three questions the court knows for the subjective test for entrapment. The first question is whether or not the government induced the accused to commit a crime. Set out in the motion to dismiss, it was almost stipulated to by the state that the confidential informant was an agent of the government working off a 15-year, I believe, minimum mandatory drug trafficking sentence that he had, and I believe he's serving prison time now. So the first issue with the three-pronged test is satisfied right off the bat. The second question, I think, is where the evidence needs to be used.
Do we have a complete record here?
I believe so.
Well, the confidential informant's deposition was taken. I think it was relied upon by the trial court in making its decision. It was used in the hearing, I think, but we don't have it in the record, do we?
Your Honor, I believe you do. I know in the directions to the clerk we asked for the entire record.
Was it a supplemental?
I don't believe any supplemental records were issued. I think in the directions to the clerk and the request to the clerk was for the entire record. And I believe it was entered into evidence at the time of the motion to dismiss. So it should have been part of the record.
The clerk's note here is wrong because the clerk's note here indicates that the CI's deposition is not in the record.
So that it was not in
the state contends that it's not in the record either.
I believe that was
I guess my question to you is, and maybe the attorney for the state can enlighten us whether it is or is not in the record, but if it's not in the record, does that make the record incomplete when the confidential informant, according to my notes, testified that there was no harassment, there was no repeated calling, and that disputes the statements made by the defendant that she was basically harassed into getting involved in this? And if that's the case, doesn't that create a fact issue for the jury to resolve? And how do we determine that without having a complete record?
It's the very first issue that they've addressed in their brief.
Page 13 of their brief. Because Santiago-Rodriguez has failed to provide the court with a complete record, she cannot establish that the trial judge committed any error. And the complaint was that Benny, the CI, testified that he simply BS'd with her a couple times. She's the one who immediately brought up that she had pills. That was argued. And without a record, if the trial court relied on that, it's hard for you to establish any error if you didn't give us a complete record. That's part of their argument. I don't know why you'd come unprepared to address that or wouldn't know that that was not in the record.
Your Honor, I did read the state's brief, and I do understand that. I believed it was part of the record. I don't know if the trial court, I'm sorry I did not argue the motion to dismiss to the trial court. I don't know if they had the complete deposition.
The record reflects that she had it and was going to take it and read it. I mean, that's what it says in the hearing transcript.
Yes, sir.
So it's clear that it was presented and relied upon by the judge in the ruling. But it's not part of the record on appeal. In other words, it's not in front of us. It wasn't secured and brought from the trial court.
I believe that was just an oversight that it wasn't included in the record. I don't know how else to answer that question. I apologize. I
Well,
know that
if it's not in the record and the trial court basically said it's an issue for the jury to resolve, how do we, what are we supposed to do when, that seems to me to be an important component of the record and, important testimony that refutes the allegations made by the defendant that this was nothing more than harassment and she was kind of bullied into this. I mean, what are we supposed to do? How do we say that the trial court was wrong in saying that this was an issue of fact for the jury to resolve?
Possibly using the evidence of the testimony of the agent and also the testimony of Ms. Santiago-Rodriguez on the stand at the motion to dismiss.
Of the agent? Didn't the agent testify that, he basically met with her in a restaurant and really that there was, I don't think that there was any testimony presented by the agent that would say that this was a case of repeated harassment, repeated telephone calls and badgering to get her involved in a crime that she wouldn't have otherwise gotten involved in. I mean, the agent's testimony wouldn't support that, would it?
No, I don't believe it would, but I believe the agent's testimony was not credible. It was all over the place. He was answering questions one way when the state was asking him questions and then a different way when the defense was asking him questions. And then the defense would ask him, did you remember your deposition? And he would change his answer a third time. His answers were not credible. They were all over the place. He admitted he didn't know who contacted who first or how many times. He also said that he couldn't remember if she said, I don't want to have anything to do with this. I'm not a drug dealer. I'm not dealing with drugs. I'm doing a favor for a friend that I guess was the friend of a boyfriend or a jailmate of her ex-boyfriend at the time who said, she's a partier. She goes to clubs. She may know people who deal drugs. The boyfriend never said, well, she's a drug dealer or she, pushes ecstasy or something else on the side.
If the trial court basically finds that there are disputed issues of fact, doesn't the case law say that the jury should resolve that?
It does, Your Honor, but I don't believe
So how is there no disputed issue of fact when the defendant is saying one thing? The confidential informant apparently in the deposition contradicts what the defendant was saying, and then the agent just gives testimony that doesn't reveal anything that would support the defendant's testimony about harassment and constant calling and badgering and that sort of thing. So the trial court came with the conclusion, and I think there's sufficient indications in the record that the trial court took the CI's deposition and looked at it in making the decision. So all the trial court said was, look, I think there are disputed issues of fact, let the jury resolve it. And I'm having a hard time getting past that, not being a proper resolution of the case. And then you entered a plea preserving your right to appeal, so you didn't take the trial court up on the offer to let the jury resolve it. And so
I believe the reasoning behind the taking the plea at the time after the motion to dismiss was denied. The second case against her, I believe there were two. There was a May case and then a July case. And the second case with the greater amount of illegal narcotics was actually null pros by the state. And they stipulated that the motion to dismiss was dispositive on the record. So an appeal could go forward on whether or not the issue of entrapment should have been handled by the judge at the motion to dismiss and not submitted to the jury. The judge it doesn't have to be submitted to the jury. I believe the fact...
I mean, if the jury found that she was not predisposed, then that would take care of the second case anyway, right? I mean, if she wasn't predisposed before the first case, then...
That's correct.
So, I mean, if there was a question of fact, I'm having a hard time understanding what the logic was of not presenting that to the jury, really.
I think that the defense felt that taking an appeal on the issue of whether or not this was actually entrapment using the testimony of the defendant and the agent, I believe the defense found that it would have been a better outcome or a better way to argue for an outcome other than a 3-year minimum mandatory, which the defendant was facing had she been found guilty by a jury.
But still, the appellate court would have to have the testimony of the CI to examine to determine whether or not the defense is right, that as a matter of law, the trial court had to enter an order on entrapment, and we just don't have it.
Yes, ma'am. If you will allow me to supplement the record.
It's too late
today.
for that.
Thank you.
The state raised it as its first argument in its brief, and to our surprise, there was no reaction on the part of the defendant. We don't know what it would show. Frankly, the indications that I've seen suggest that it was a question of fact and the trial court's disposition was proper, but we won't know because we don't have the deposition.
Yes, ma'am.
Thank you.
May I reserve the rest of my time?
Sure.
Thank you.
May it please the court, my name is Bonnie Parrish. I represent the state of Florida in this case. The deposition is not in the record. On page 83 of the hearing transcript, the trial judge says she's going to take the deposition and consider it along with the testimony that she heard from the defendant and from the agent. Based on that, she had to have considered that in making her ruling, and without that in the record, there's nothing for this court to review. You can't say whether she was right or wrong because you don't have all the evidence. Even on the facts that we do have, even on the transcript, there is a factual dispute. The agent's testimony pretty well establishes that she wasn't induced. She was ready and willing to participate, and even her own testimony. She testified that she was doing this as a favor for her friend. There was no testimony of any threats or promises or, that she was looking to have a relationship with the CI. There was no testimony about that at all. Just that there were some phone calls and that he would stop by, and it's the state's position that's
I guess
not enough.
Part of that argument I don't understand because the agent came along long after the CI, acting on behalf of the government, had contact with the defendant. So the question is whether she was predisposed prior to the contact with the government, which in this case was contact with the CI. So I don't understand. I mean, I agree that the agent's testimony was by the time he met with her, she seemed really eager.
Well, I would go back
to... I don't know how that establishes predisposition. I mean, if you only had her testimony, it would seem to be that would show no predisposition.
Her testimony would show.
Right.
Now, I would disagree with that because I don't think she even testified that the contact was to the degree that she was just continually badgered and Judge Sawaya used bully. Not really. And the phone call, she met the CI in November. None of this took place until May. The CI testified to a handful of calls. She never testified to a number, but she also, it wasn't a daily phone call. I think she said maybe weekly. I don't even think she established that she was induced, but even if she did, I think based on the testimony of the CI, she was ready and willing. She brought up the acid. She brought up when he asked about pills, she got excited about that. And as a matter of fact, she moved in between the first transaction and the second transaction and contacted the agent to tell him that she had moved and where she was so that they could continue with their dealings. So this was a jury question. They should have gone to trial. Maybe she would have been a good witness. I don't know. Maybe the jury would have believed her. But based on this record, there isn't enough to show that the trial judge abused his discretion, her discretion, in denying the motion to dismiss, and ask that you affirm that.
Thank you.
Thank you.
Thank you for allowing me to have some extra time. Just as a couple of things to clarify, in the motion to dismiss, the agent actually testified that he looked up directions to her house, and he may or may not have contacted her to find out how to get there. So it wasn't, she didn't pick up the phone and say, hey, come on over, I've got more pills for you this time. Oh, by the way, I moved, this is how you get to my house. He couldn't remember he testified that he looked up the directions, found her house, and then he couldn't remember who initiated a phone conversation to get directions or know how to get there. Also, getting lit up or getting excited, that's speculative at best. But again, just like the state was arguing, the state just said
Well, the testimony was she perked up, something like that.
Yes, sir. I don't know, maybe I don't know. We weren't there, we don't know about that. That was the testimony by the agent, but it's I guess just his honest opinion on him trying to make a drug deal and do his job the way he was supposed to do. So the state just argued that the defendant met the confidential informant back in November, but nothing happened until May. That fits into the second question in the three-prong Supreme Court test of no predisposition to commit a crime. She met him in November because he got her boyfriend a job and she took them to work. So from November to May, when the confidential informant got in big trouble with a 15-year minimum mandatory and had to work off his time so he wouldn't have to spend 15 years day for day in jail, he decided he was going to go where he thought the drugs were and asked the boifriend.
That plays like a record with all CIs. That's what CIs do. Most of them anyway. If they've been caught and they want to work off some of the charges, they try and make cases against other people, and the police are more than willing to utilize their assistance. So that's just standard practice, isn't it?
It is standard practice, but we haven't seen any propensity. The state didn't show any propensity for her to commit the crime. And so if she can show that she doesn't have a propensity to commit the crime, the burden actually shifts back to the state to show that she does. And there was never anything in the motion to dismiss that the state presented to show that she had a propensity to commit the crime. And the state, that was outlined in the brief that the defendant submitted, or the appellant submitted, and it's also outlined in the brief that the state submitted on page 15, saying that as soon as the defendant produces evidence of no predisposition to the crime that she was induced to commit, the burden then shifts back to the state. And there was no proof in this, that in the motion to dismiss, that there was any evidence of predisposition of the crime. Actually, the agent testified that he didn't know who she was. The CI, he said the CI, I guess, found her through the boyfriend, didn't know who the boyfriend was. All they knew was that she partied at clubs and might know somebody that dealt some drugs. Nobody ever said she dealt drugs or she was even doing drugs. That wasn't even brought up in this. I know that the state doesn't like when the defense relies on no criminal history, but she has no criminal history. She's 28 years old. She doesn't have any criminal history in drugs, and I know the state would argue that, that doesn't mean maybe she just didn't get caught, but that shows a lack of propensity, which makes the burden shift back over to the state to prove that she does have a propensity to commit the crime. Other evidence that was presented in the motion to dismiss, the fact that she had a bag of pills that was just sitting around her house apparently for a week because the agent couldn't get there to pick them up. She didn't go out and sell the pills or do anything with them or take them herself. They were apparently bagged or whatever where the drug dealer had left them there, and the agent was to pick them up. So I believe that the second question is really what it hinges on in this case, and she was entrapped. She was definitely entrapped, and there was no propensity for her to commit the crime.
Thank you, counsel.
Thank you, Your Honors.